one of the things I've noticed is that everybody has read the paper. It's quite extraordinary. That doesn't usually happen. And so rather than take 10 minutes out of questions that you could ask me, I'll waive my 10 minutes and go right to John.
So I think his paper really seeks to do to originalism what Charles Beard did to the United States Constitution. Beard purported to show that the document was a conspiracy of oligarchs to perpetuate the power of the rich. Rick purports to show the Constitution represented a cram down of its contents by mainly Federalists on the mainly helpless anti-Federalists, and the Federalists' exploitation of their agenda-setting power and their use of strategic ambiguity undermines the fixed interpretive meaning of the Constitution in all but indisputably obvious provisions. While the paper is thus fascinating and just hugely ambitious, I have three principal reservations. One is historical. I doubt the Federalists were in quite as strong a position as Rick makes out. Two are legal. First, as a positive matter, even if this were the Federalist strategy, Rick doesn't present enough evidence to suggest that it changed the public meaning of the document, widening what modern originalists call the construction zone. Second, considering Rick's position as a normative rather than positive, it seems to me odd to argue for more pragmatic decision-making when that mode of giving the Constitution effect would reward the Federalists cram down and realize the anti-Federalists' worst fears. Even before getting to his essential cram-down thesis, Rick asserts the Constitution is full of ambiguities. Technically, I think it might be better for him to talk of vagueness as well as ambiguity, because most originalists concede that vagueness is harder to resolve than ambiguities. Of course, the general question of constitutional indeterminacy is a debate which I really can't resolve here. Nevertheless, I think his most striking claim seems implausible to me. Is it really true, as Rick suggests, that there's no interpretive rule for resolving ambiguity, as most originalists use the term, that is, to determine which meaning to follow when there are two plausible meanings? A rule preferring a better meaning on a preponderance of the evidence standard seems to have been respected in interpretation at the time. For instance, in the bank debate, Fisher-Ames expressly invoked the idea that even when a matter of interpretation was in doubt, he was obliged to seek the better supported view. Moreover, when there was a reason to depart from a preponderance rule for evidence at the time of the framing, now that was generally explicitly stated. The reasonable doubt standard for criminal verdicts, celebrated by Blackstone is a paradigm example, but there are others as well. And interpreters at the time all seemed to be seeking the most plausible interpretation. But now let me turn to the heart of Rick's paper. His suggestion that the Federalist use of strategic ambiguity in a cram down widens indeterminacy by changing how the Constitution either was to be or should be interpreted. His argument depends on a claim about history, that the mainly Federalist framers were confident that they could exploit their position vis-a-vis the anti-Federalist ratifiers by giving them essentially a take-it-or-leave-it choice. But that story to me seems somewhat too simple, because the framers themselves faced a great deal of uncertainty. First, it wasn't clear the Continental Congress would transmit the work of the convention for ratification. Second, they faced the real possibility of another convention had the requisite states not ratified. Finally, the ratification conventions could have conditioned their ratifications on amendments. Many conventions, in fact, suggested amendments, and when the Federalist Congress dragged their feet in enacting them, some people, in fact, threatened a second convention. The rights, that we now know as the Bill of Rights, the amendments that were passed, were something Federalists strongly opposed, and that was the result. And so while it may seem to Rick that strategic ambiguity could have been a successful strategy in retrospect, at the time the prospective hurdles the framers faced would have made it seem quite risky. But let's assume that at least some ambiguities were intentionally strategic. Did this fact change as a positive matter the interpretive approach that would otherwise have been applied? Even before considering the evidence at the framing, it should be noted that strategic ambiguity is not unknown to legislatures, like parliaments, that permit amendments. In other words, the modes of interpretation familiar to the framers were already built around a system in which strategic ambiguity could be present. For instance, strategic ambiguity remains a staple of the legislative process and therefore of legislative interpretation courses. But in any event, I'm not persuaded by the evidence Rick presents that a cram down modified the interpretive approach. In other words, changed the approach at the time. Consider Edmund Randolph, who I think is Rick's poster boy in this paper for recognizing the Federalist strategy. But whether he recognized the strategic ambiguity, there's no evidence that this recognition changed Randolph's view of the proper scope or method of interpretation, or enlarged his view of what is now called the construction zone. In the speech at the Virginia Ratifying Convention that Rick quotes, indeed, Randolph does suggest that he'll rectify ambiguities by amendments. But that statement doesn't address how we'll interpret the Constitution in the absence of amendments. And in fact, we don't have to guess how Randolph thought the Constitution should be interpreted. We know it was emphatically not Randolph's position as a constitutional interpreter to concede large indeterminacies to the Constitution and resolve them on pragmatic grounds. We know that from his opinion as Attorney General in the Bank of the United States, an issue I think that Rick would see as quintessentially not resolved by plain meaning. There, Randolph spends a great deal of time trying to figure out what are the appropriate rules of interpretation to apply, and none about the pragmatic arguments for or against the bank. And Randolph, in this respect, is representative of the diverse cabinet opinions on the bank, which do come to different conclusions, but all invoke legal interpretive rules. In his opinion, in fact, Hamilton states that the usual and established rules should guide interpretation. The bank opinions, in turn, are also representative of the founding generation. Marshall clarifies the ambiguity of necessity of McCulloch by implying interpretive principles like what we would call intertextualism that Rick would appear to reject, not simply by relying on pragmatic arguments. In other opinions, he invokes other legal rules like the rule against surpluses and the absurdity rule. No one, not Federalists like Marshall, nor Republicans like St. George Tucker, mentions strategic ambiguity as a consideration to guide proper interpretation. Instead, they all appear to interpret the Constitution with rules they previously applied to statutes and state constitutions. It's true that they sometimes debate how the rules should be modified by the nature of the relative brevity or the purpose of the Constitution, but the question of which rules of statutory interpretation need revision in light of differences between a Constitution and a statute, that be present regardless of concern about strategic ambiguity. The fact that everyone applied legal interpretive rules to the bank debate immediately after the ratification cast doubt on Rick's more general point that legal interpretive rules really can't be applied, weren't expected to be applicable. Mockery of the language of the law, which Rick gives some examples of, is not at all the same as expecting that it would not be applied. Mockery often reflects fear. For instance, while the famous anti-federalist Brutus wanted a constitution written in ordinary language, he believed it be read with a lawyer's craft. That was the reason for his opposition. Hamilton's response in the Federalist was not to deny that judges would deploy legal rules. Instead, he said that their arbitrary, quote, their arbitrary discretion would be bound by, quote, strict rules. Edmund Randolph, in the very ratification speech Rick quotes, wishes there had been more technical terms, I think to make, quote, more technical terms to make the document clearer. Another way to look at Rick's argument, however, is less positive than normative. Indeed, he does briefly suggest that one really can isolate normative from positive arguments in interpretation. That's a claim I think is not fully defended in the paper, in any event is too large to take on here. But I do want to suggest that given his view of the Federalist cram down, his conclusion that constitutional law should permit pragmatic, consequentialist judgments to govern is not attractive on his own premises. After all, the anti-federalists believed that a main problem of the Constitution was that those who interpret it, most notably the federal judiciary, would be biased in the direction of what they most feared, which was consolidated government. Thus, a jurisprudence of pragmatic judgments, wielded by that institution, rather than one restrained by legal meaning, would lead to results they hated. A more attractively normative jurisprudence, I think on Rick's assumption, would be a Jeffersonian jurisprudence that read federal powers narrowly and gave a lot of deference to state legislatures. Again, in Randolph's ratification speech, the very one Rick relies on, Randolph makes that kind of suggestion. He suggests that maybe they should propose to ratification a kind of style of interpretation that would limit federal powers to, quote, express delegations. Thus, one difference between Beard and Rick, it seems to me, is that Beard's positive claims provide better support for the progressive norms for which they're typically used. Byrd's claims about the Constitution's oligarchical origins argue for abandoning its restraints on democracy in favor of the people's pretty much unconstrained power. But if it is the case that the Constitution has origins in a federalist cram-down, it doesn't seem that that would support a vision of constitutional law that accelerates the very centralizing forces that the victims of the cram-down detested.
What wonderful comments, John. Thank you very much. Just to respond to you, I think it would be both foolish and disrespectful for me not to say a couple of things. On the question of the concept of ambiguity and whether some canon, beyond a reasonable doubt, preponderance of the evidence, something could be used to decide when texts were ambiguous, I simply believe that the concept of ambiguity is an ambiguous concept. It's one of the most ambiguous concepts in the law. When should we declare a tie? And of course, there are legal methods used in treaties, criminal law, civil law, etc., for resolving these kinds of questions. But the problem is that we don't know which one should be used with this odd sort of constitution. So I want to say that's what the point of part one is, to say there wasn't a clear sense of how to declare when text was ambiguous. And I believe the structure of Article 7, the ratification process, provides a reason to presume that apparent ambiguities were both deliberate and strategic, simply because Article 7 defines an ultimatum game, which is likely to inspire deep resentment from the Anti-Federalists. And indeed, the single most common resentment they expressed was about Article 7. They had many, many different complaints, but the single most common complaint was that this was a cram down. And the Federalists were quite aware of this, and so they had to have some answer, some way to deal with it. There is two ways to deal with resentment from the responder in an ultimatum game. One way is to provide a specific deal. It's called the divide the dollar, and these experiments are done all the time. So I say, here's $1. I propose to divide it 99 cents to 1 cent. I get 99. However, if you turn down the steal, nobody gets anything. Typically what happens is the person says, screw it, I'm going to deprive you of 99 even though I have to lose 1 cent. And so to appease resentment, you try to divide the dollar in a more fair way with a precise bargain. And so one way to respond to an ultimatum game is to say, okay, here's $1, I get 60, you get 40, or I get 55, you get 45. That would be the case if the Federalists were negotiating with the Anti-Federalists in Philadelphia, and they wrote out an articulated deal, including many specific provisions like a ban on corporation chartering power. But the Federalists couldn't do that. There wasn't a single Westerner and very few Anti-Federalists, Yates and Lansing leaving early, at the convention. So they could actually not write a specific deal. They had no one to talk to. Moreover, the Anti-Federalists were so disorganized, especially in the Western reaches, that they did not actually know what the Anti-Federalists wanted. And so my suggestion is, it wasn't that they were trying to be unscrupulous. Ambiguity was the fairest thing they could do to assuage resentment. And Edmund Randolph picks up on this. He understands that the only way they can make this cram down seem fair is if they say, look, this is a dangerously ambiguous document. We don't know what it means. It's written in plain, simple language that's hard to interpret because it has to be abstract in general. And we suggest that all the problems be resolved post-ratification on the details. So that's my claim. It's not a Beardian claim that they were unscrupulous, but that they were transparently ambiguous. That's what strategic ambiguity is. It's transparent ambiguity. And so it wasn't a dirty dodge. It was a forthright acknowledgement that in an ultimatum game, the only way you can split the dollar fairly is by not offering a specific bargain when there's asymmetries of information and the other party's not represented at the table when the document is drafted. So that's my rough claim, and I hope that's responsive to your claims. As to post-enactment debates about the bank, of course, the whole point, Randolph said, prior to enactment, is that after enactment, as the musical says, as Cole Porter would say, anything goes. Use text, use history, use purpose. As Jonathan Gannap has beautifully illustrated, there was zero agreement in the bank debate about what canons of construction to use to resolve this problem. Everybody chose the one that would give them the most advantage. And I think that's exactly what the Federalists promised, properly interpreted, before enactment. After enactment, say what you want. We are not going to impose upon you a deal that we wrote now, because we actually wrote no very specific deal right now.